Important points of offer under the Indian Contract Act 1872. First, we will understand what exactly is the definition of offer. As per Section 2A of the Indian Contract Act 1872, it defines as offer as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence, he is said to make a proposal. Now, I'll give you an example. For example, A offers rupees 10 to B if he would mow his lawn. The promise to pay rupees 10 is binding as soon as B promises to mow the lawn, until the A is free to withdraw his offer. Now we are going to discuss about the essentials of a valid offer. The essentials of a valid offer are as follows. First point is, an offer must be one to give rise to legal consequences. So, to constitute an offer, the offerer must intend to create a legal obligation. Where such intention is lacking, the agreement is not a contract. Further, where an agreement clearly provides that it shall not be subject to legal jurisdiction, there is no contract between the parties. Social invitations are examples of offers made without the intention of creating legal obligations. So, for example, if X invites Y to dinner and then forgets all about it and goes to town on the stipulated date, Y cannot claim compensation for expense and inconvenience, as there was no intention to create a legal obligation. Now, we are going to discuss about the second essential, that is, the terms of the offer must be definite or capable of being made definite. An offer must be certain and definite and not uncertain, vague or loose. If the offer is uncertain, an essential element is lacking and it cannot be accepted. Same thing happened in Taylor versus Porrington, 1855. A promised B to take a lease of the house for 3 years at £85 per annum. If the house were put into thorough repair and the drawing rooms decorated according to present style, held that the terms were too uncertain, that the promise could not be enforced. Now, third point is, an offer must be distinguished from an invitation to offer. An offer is to be distinguished from an invitation to offer, exemplified by advertisements, marked price of goods displayed in shop windows or catalogs mentioning prices of goods. In all such cases, the traders or advertisers is simply inviting an offer. For example, that is indicating that he is willing to consider an offer to pay the goods on the terms set out in the advertisement or catalog. He is not making an offer. Now, there is a case law, that is Harvey versus Facey, 1893. X telegraphed to A, will you sell bumper hall pen? Telegraph, lowest cash price, answer paid. A replied by telegram, lowest price bumper hall pen is £900. X telegraphed, we agree to buy £900, asked by you. In a suit by X against A, it was held that mere statements of the lowest price at which the vendor would sell his estate bumper hall pen contained no implied offer to sell at the price, and that the reply was no reply to the question whether agreed to sell the property. It was therefore held that there was no concluded contract between the parties. Now, fourth essential ingredient of offer is, every offer must be communicated to the offeree. Every offer must be made known to the offeree, otherwise he will not be in a position to accept, inasmuch as he will have no knowledge of the offer. The mere desire to enter into an agreement will not constitute an offer. As observed by Lord Linley, a state of mind not communicated cannot be regarded in dealings between man and man. Now, in offers also there are two categories: general and specific offers. So an offer need not always be made to as certain person, but it is necessary that an as certain person should accept it. For example, if a person offers a reward to anyone who finds his lost diamond ring, the finder can successfully claim the reward. The position will, however, be different if the finder has no knowledge of the reward. Now, for example, landman Shukul versus Gauri Datta. It was held that the servant was not entitled to claim the reward because it came to his knowledge after he had discovered the boy, which he was obliged to do as a servant. Where an offer is made to the whole world, acceptance of the offer and performance of the condition will be sufficient for making it an enforceable contract. So, again, there is a well known illustrative English case of Carlyle versus Carbolic Smokeball Company. In this case, the defendants were proprietors and vendors of Carbolic Smokeball. They advertised a reward of £100 to any person who contracted influenza after using the smoke ball for a certain period according to the printed directions. In order to show their sincerity, they also deposited £1,000 in a bank for the same purpose. The plaintiff, a lady, used the smoke ball according to the printed directions, yet she contracted influenza. She brought an action to claim the reward. It was held that she was entitled to claim the reward. The court pointed out that in advertisement cases, an offer may be made to the whole world, but it becomes a promise only when it is accepted by an ascertained person. Thank you.